The first case scheduled for this morning is Carl Joseph Roberto, and the parties are ready. All right, you may begin, ma'am. Excuse me.
Thank you, Your Honor. My name is Sharon Stedman, and I represent the defendant appellant in this case, Carl Roberto. There's only one issue in this case, and that's whether or not the trial court abused its discretion in denying Mr. Roberto's petition to seal his criminal court records. The issue does not involve non-judicial criminal history. Therefore, the defendant's position is there was no need for a certificate of eligibility to be provided by the Florida Department of Law Enforcement. This case was before this honorable court once before when his prior counsel had received a conditional pardon from the governor, and upon receiving that conditional pardon, he filed a request, an application with the Florida Department of Law Enforcement for a petition of, for a certificate of eligibility to have his criminal history sealed.
Would you agree with me that there's a division of labor in this case, that the judiciary has part of the work assignment and the FDLE has part of the work assignment?
Not as to this particular case, no, Your Honor.
All right. Is your argument then that the Florida Department of Law Enforcement can be ordered or directed to give clearance to Mr. Roberto for to the judge, then for the judge to act and grant his motion?
I'm not sure as far as ordering the FDLE to provide Mr. Roberto with a certificate of eligibility?
Yes.
Well, Your Honor, we didn't request that in this case.
Well, don't you need that as a predicate to get the judge to act?
No, Your Honor, and that's where the confusion lies, because it specifically says under the statute, the Florida Department of Law Enforcement issues a certificate of eligibility if a person is seeking to have his non-judicial, an agency, arrest or criminal history sealed. And in this case, the only thing that Mr. Roberto requested of the trial court was for the trial court to seal the trial court's own records. There was no mention of history, his criminal history, so therefore there was no need for the Florida Department of Law Enforcement to issue a certificate of eligibility. They were not, the court, Mr. Roberto did not request that his criminal history be sealed. In this case... Well,
then isn't it discretionary with the court to either grant or deny the request based on what the court has before it?
Yes, Your Honor, that most definitely does. This is whether or not the trial court abused its discretion in denying it. But the case...
Excuse me, does the trial court really have discretion? Isn't this a timing question of when the legislature amended the statute? Didn't the legislature amend, isn't it Section 943.059? And didn't your request come subsequent to the amendment? And therefore, the court didn't have discretion?
Your Honor, we're not relying on the statute. The statute only comes into, has relevance if the defendant were requesting that his criminal history be sealed. And again, Mr. Roberto, it's just simply whether or not the trial court abused its discretion in sealing Mr. Roberto's criminal records in front of the trial court. And only the trial court has jurisdiction. The statute can't give jurisdiction or take jurisdiction away from the trial court to seal its own records. That's under the Constitution. It can't be taken away by statute.
Does the legislature have the authority to tell the courts what records they can and cannot seal?
Specific crimes, but this comes under the rules, the criminal rules of procedure, Your Honor. There are no specific crimes that are excluded under the rules of procedure that give the court the jurisdiction to seal its own criminal records. And that's all that's all Mr. Roberto asked for. And there is no statutory preclusion for this particular crime that Mr. Roberto was accused, well, not accused of, that he pled nolo to. It was for trafficking in Quaaludes back in 1981 in Daytona Beach. He was a student at the time. I happen to...
Well, if it's an abuse of discretion, you said that there's no mandate required from FDLE, that it's totally discretionary with the court under the statute as it existed at that time. How then did the judge violate his discretion or abuse his discretion specifically in this case?
Your Honor, the case that I rely on, most of the cases discuss the FDLE certificate of eligibility.
Hold
And I think
on,
that's-
Ms. Steffen, let's see if we can get this redirected. Here's the issue. What's the definition of an abuse of discretion?
Well, Your Honor, that's the case of Anderson that I relied on in my brief discusses the abuse of discretion standard.
But what does that mean?
It says the discretion granted does not permit arbitrary, capricious, or whimsical denial of expunction. Instead, the court must decide.
What does the Supreme Court say that it means in the Kanakaris case?
Well, Your Honor, that's whether or not reasonable people could disagree.
Yeah.
But in this case.
Hold on. Will you agree that the law of this state is that if reasonable people could disagree, then there's no abuse of discretion by what the trial judge did? In fact, isn't the rule that no reasonable trial judge would have taken the action taken by the trial judge here?
Yes, Your Honor.
And why would you say that this is an action that is so unreasonable that no other reasonable trial judge would have taken it?
Because, Your Honor, I believe in the case of Anderson, when they talk about the specific sealing of court records, this is the only crime that Carl has ever committed. He's never been charged or convicted of any offense other than this one in the state of Florida. He was a college student. I mean, there are no ground. They give specific examples of a firefighter or law enforcement officer who was charged with lewd and lascivious on a child. There are certain circumstances that the Anderson court discusses that there are good ground. It's a public policy issue, whether or not the public has a right to know about certain offenses committed by certain people. There's just no circumstances. The case law says that they have to look at the circumstances of the particular case.
Do you think that trafficking in narcotics is not a serious offense?
No, Your Honor, I did not say that. I certainly did not say it's a felony. It's a serious offense. I did not say that it wasn't a serious offense, but I said that there's no public interest in knowing of Carl Roberto's criminal record. There's no public interest.
Well, the judge was interested, and it's the judge's call. And the reason I ask about FDLE is since you argue there's no mandate, that FDLE, in essence, is not involved, and that he's not automatically ordered by the statute, the judge, to reinstate or to seal, it's then the judge's decision. And the judge looked at it, and the judge said no. So how then is the judge in error when it's the judge's discretion? And by analogy, there are cases where the judge has been upheld for refusing to grant promotion.
Your Honor, in the research that I have found, the only cases that say the trial court did not abuse its discretion are the cases of the firefighter, a law enforcement officer. Anderson reversed a denial of a petition to expunge criminal records. The case of Anderson that I relied on, they reversed, and they discussed the abuse of discretion standard because they said the court's got to look at the circumstances of each particular case. And if you look at the circumstances of this particular case, there's no public interest in knowing of Carl Roberto's criminal record. I mean, he was a college student. He pled to it. He's accepted responsibility. He was terminated early because he did, in fact, do everything he was supposed to do to such a degree that they terminated his probation early. He has never committed or been accused of committing another crime in the state of Florida since 1981. Again, there's just no public interest in knowing of Carl Roberto's criminal history in this case. There is no circumstance.
Hasn't the legislature said that you can't seal an agency record of a drug trafficking conviction?
Yes, Your Honor. We haven't asked that an agency record be sealed.
But doesn't that suggest that there is a public interest in keeping this information out there in the public domain?
Well, Your Honor, that has to do with criminal history of investigations from the Florida Department of Law Enforcement. And normally they do, the ones that I am familiar with, they do statewide. They do, big narcotic busts, and they do, extents when they're dealing with, trafficking in large quantities among drug dealers. And in this case, this is a single person who picked up a package at the post office. Again, it wasn't that he was not they never accused him of being a drug dealer. or, you know, a big man on a totem pole. He was a college student who was buying Quaaludes through the mail or picking them up. I mean, there's just no compelling interest at stake.
In the case you cite, the court wrote that it is within the discretion of the court to grant or deny the motion, and it's quoting, however, the petition is addressed to the sound discretion of the trial court, and the petition may be denied if there's a good reason for denial based on facts and circumstances of the individual case. And then they said the judge gave a wrong reason, and that's why they reversed. But in this case, are you arguing that the judge gave a wrong reason?
No, Your Honor, we asked for a hearing on this motion so that we could present the argument for the circumstances of this case. It was denied. I mean, there was no, she just summarily denied without a hearing, without hearing the circumstances of the case other than what it was based on. He filed the affidavit. We went by the specific criminal rule of procedure 3.692. He filed an affidavit that's in compliance with, he's presumed under the rule, he's presumed to have, it's presumptive that he should have his record sealed, and that's a presumption under the rule. And therefore, I mean, in order for the trial court to overcome the trial court's presumption that he should have his record sealed, there has to be some statement as to why it should not be granted. But in this case, we were not granted a hearing. The court did not hear anything, just summarily denied it. And that, Your Honor, is an abuse of discretion under the rule and under the case law. I mean, reserved.
You've got let's say 4 minutes. Thank you, ma'am.
Thank you very much.
May it please the Court, my name is Ann Phillips. I'm here on behalf of the State of Florida. It's the State's position that there was no abuse of discretion in this case. The Court's order denying says that it had reviewed the file, considered the same, and being otherwise fully advised of the premises, it denied the motion. The State would also point out that Mr. Roberto is not eligible for the sealing of his records as he was adjudicated guilty. The affidavit set forth in the rule does state that you have to be able to state you were not adjudicated guilty of the crime. He was adjudicated here, so I don't believe he was eligible, and the trial court did not abuse its discretion. If there's no specific questions, we'll ask that you affirm.
Hardly had a chance to get your breath.
Sure. The only issue, Your Honor, that I'd like to address is because he was convicted of the crime, FDLE cannot issue a certificate of eligibility. That's why the statute doesn't come into play. FDLE cannot issue a certificate of eligibility if the person has been convicted of the crime. And this
we now know, and from your questioning previously and your answers, that FDLE can't get involved. We know that there's no statute mandating that the court correct, and we know it's up to the judge's discretion. And in this case, from subsequent statutes, we know that the legislature has amended to pick up cases like Quaaludes. So other than the judge's decision not to agree with your petition, is there a case you can cite specifically that says the judge is mandated to do so?
Your Honor, the court is not mandated to, but there is a presumption that Mr. Roberto was entitled to a sealing of his court records.
Which was removed by the judge by entry of the order.
Well, the court did not address it. At a minimum, we would ask that it remand for an evidentiary hearing so we can present it to the trial judge. We were not allowed to present. The court there's a presumption in Mr. Roberto's favor. The trial court did not discuss his presumption, and I submit that in order for the trial court to overcome the presumption, the court had to state why in this particular case Mr. Roberto was not entitled to have his criminal records sealed, because there is a presumption that he's entitled to it. He fits within the rule. He filed the affidavit. There's nothing in the record. There was nothing before the trial court in the record that the trial court had as to why he wasn't entitled to the presumption to have his criminal record sealed. And therefore, since it wasn't overcome, the presumption wasn't overcome by the trial court's order or anything in the record, I say he was entitled to either have his criminal records sealed or to at least an evidentiary hearing to present. There is a presumption, and it was not overcome by the state. It wasn't overcome by the trial court. the presumption is still there, and he was, therefore, in my own personal opinion, under the case law, he was entitled to have his record sealed. There are no circumstances in front of the trial judge. There was nothing in front of the trial judge as to any circumstances as to why it shouldn't be sealed. The state didn't file a response. There's nothing in the record that the trial court had that would show that he's not entitled to have his criminal record sealed. And therefore, under the case law and under Anderson, it was an abuse of discretion to deny his petition to seal.
Thank you, ma'am.
Do you have a question, Your Honor?
Well, I'm just curious about this. Assuming the trial judge had sealed the court file, what's the benefit to Mr. Roberto? The reality of the arrest and the adjudication for drug trafficking is still in the public record, isn't it?
Well, the records itself as to the investigative report in his particular case would be sealed, Your Honor. Anything in the court file would be sealed.
But anyone who wanted to know could find out from the public record that he'd been adjudicated guilty of trafficking in narcotics, couldn't they?
Not if it were sealed, Your Honor. They have to show a reason, they have to present to the court to have it unsealed in order to...
From the court file, but the agency record's not sealed, is it?
No, Your Honor, I don't know if the agency did an investigation.
Curious. Well, I was curious. If they Googled him, would they pick up the Southern Reporter and the newspaper reports as well as the various public notices, newspaper, et cetera, about him?
Your Honor, you're asking the wrong person, because I had to ask them whether they would Google me.
Thank you, ma'am.
I do not know. I can't answer that question.
Thank you.
Sorry.